Vidhi Vichar legal lecture series, legal internship programs, and much more. The theme for today's webinar is digital evidence, and I would like to take this opportunity to welcome the eminent speaker of today's webinar, Advocate Mr. Akhil Vyas. Akhil Vyas, sir, has a degree in law from Delhi. He completed his master's in law from National Law University, Jodhpur. He has been practicing as an advocate since the year 2008. Sir practices in the civil, criminal, and corporate side of law. Mr. Participated in various conferences and seminars as a speaker as well as a participant. Sir has various research articles published in various journals as well as papers. Mr. Vyas also remained an associate in the office of Sri Baldev Raj Mahajan, who is a senior advocate and the Advocate General of Haryana. I would also like to state that Mr. Vyas is now practicing at the Honorable Punjab and Haryana High Court at Chandigarh. Sir has a successful record in handling civil as well as criminal cases, and also he has a vast experience related to cyber defamation, data theft, software piracy, and copyright infringement cases. Sir, I would like to welcome you on behalf of World Cyber Security Forum as well as Think India Chandigarh. Before we start with this knowledgeable webinar, I would like to request all the participants to kindly raise their question in the chat box, and whatever question that would be raised by you, I would be conveying that to Sir for his kind perusal. I request Sir to kindly take the stage and start with this webinar. Thank you, Sir.
Thank you, Manik. I hope I'm
Pleasure.
audible to you. The voice is
Yes, sir,
clear,
you're
right?
audible.
Yeah.
Yes, sir, you're audible.
So, probably I am very thankful to you all. Uh, Good evening, friends. I thank the organizers, that is World Cyber Security Forum and Team Think India, who have jointly conducted today's webinar. Now, I have been given the opportunity and responsibility to discuss with you the topic of digital evidence. Before jumping directly to today's topic, it would be relevant for you to understand the meaning of as defined in Indian Evidence Act. Because we can't just directly jump to digital evidence. Evidence. Evidence as per Indian Evidence Act means and includes all statements which the court permits or requires to be made before it by witnesses in relation to the matters of the fact under inquiry. Such statements are called as oral evidence. Second, all documents, including the electronic records produced for the inspection of the court, such documents are called as documentary evidence. So from this definition of evidence, we hereby conclude that all the documents, including even the electronic records after the amendment in the Act, were also included as a part of the documentary evidence. Now, proceeding further, it is apparently clear that we are living in a paperless world. So once we are living in paperless world, as a human being, we have to understand that if in a paperless world there is a crime being committed, then the crime has to be investigated, a thread-bearing inquiry has to be followed, and subsequently it has to be produced before the court of law. Discussing about cyber law, the most technical aspect of the cyber law subject is the aspect of the evidence. It would be relevant to understand that the offense committed by any person has to be proved in the court by cogent and convincing evidence so that the guilt is proved and the justice prevails. Now, convergence of computers and internet has posed maybe much more grave problems with respect to the mode of proof after the commission of crime. So there are, as we all know, two types of documentary evidence: primary evidence and secondary evidence. Primary evidence hereby includes original documents such as mail, letter, figures, whereas the secondary evidence is a photocopy, a translate copy, or a carbon copy. So, Information Technology Act 2000 has also defined a definition of the term called electronic record, because earlier, as far as the definition of evidence is concerned, I had highlighted the point that electronic records are also now included in the definition of documentary evidence. So under section 2IT of the Information Technology Amendment Act, electronic records means data, record, image, or a sound received or sent in an electronic form, or a microfilm, or a computer generated microfiche, such as data or record generated like images or sound. Example: SMS, email, documents, tape record version, a cell phone record, or any audio. Further, it includes stores received or sent on electronic form. Examples: a mobile, computer, a tab, VCD, a pen drive, or a hard drive, or a compact disc. We need to understand that the whole idea of electronic record revolves around the concept of primary evidence and the secondary evidence. But it is decided by the nature of the evidence. Like if some record is saved in a mobile phone and that mobile is produced in the court of law, then it can be directly called as a primary evidence. But if the printout is taken, then as far as my knowledge is concerned, it falls under the category of secondary evidence. It would be relevant to mention here that relevant provisions of Indian Evidence Act, which deals with the today's topic, would be section 65B of Evidence Act 1872. Now, why 1872? Why 65B? Because 65B is inserted in the Evidence Act and it relates directly to the admissibility of electronic records. These days, as a law student, you all should understand, and as a lawyer, it is important for me to say that most of the matters which a lawyer is dealing, it may be civil in nature, it may be criminal in nature, it may be under the any other act. The kind of evidence which we are getting is most likely to be electronic in nature. So, how to correlate that electronic record and how to produce it in the court of law as per the statute is relevant to understand. Now, before proceeding further, 65, it is necessary for us to understand that 65B, the bare wording, the statutory wording of 65B starts with the non-obstante clause, saying that notwithstanding anything contained in this act, any information contained in an electronic record, which is printed on a paper, stored, recorded, or copied in optical or magnetic media, produced by a computer, shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceedings without further proof or production of the original as evidence of any contents of the original or of any fact stated therein of which direct evidence would be admissible. Further, it lays down the conditions in respect of a computer output, that is, namely, a computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process the information for the purposes of any activity regularly carried on over that period by the person having lawful control over the use of this computer. I pause here for a moment. When we read a provision of law, to my understanding, we read it in totality. So once we read it in totality, we cannot read one word or one information in isolation. We have to read it in totality. So as per clause A, the last four words says regular activities carried over that period by the person having lawful control over the use of the computer. Second, B part, during the said period, information of the kind contained in the electronic record, of the kind from which the information so contained is derived, was regularly fed into the computer in the ordinary course of the said activities. C, throughout the material part of the said period, the computer was operating properly, and if not, then in respect of any period in which it was not operating properly or was out of operation during that period, was not such to the effect that electronic record or accuracy of the contents would have been hindered. The information contained in the electronic record reproduces or is derived from such information fed into the computer in the ordinary course of the said activities. The third clause says of 65B that where over any period the function of storing or processing of the information for the purposes of any activities regularly carried on over that period as mentioned in the clause A or subsection 2 was regularly performed by the computers, whether they might have been performed by a combination of computers, by different computers operating in succession, or whether by different combinations of computers operating in succession over that period, or in any other manner involving the successive operation over that period, in whatever order one or more computers or combination of computers or all the computers used for that purpose during that period. Fourth, in any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate doing by the following things, that is to say, identifying the electronic record containing the statement and describing the manner in which it was produced, giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that electronic record was produced by a computer. Now, for the purpose of this section, the fifth clause is that information shall be taken to be supplied to a computer if it is supplied thereto in any appropriate form, or whether it is so supplied directly or by the means of any appropriate equipment, whether in the course of activities carried on by any official information is supplied with a view of to its being stored or processed for the purposes of those activities by a computer operated device. Now last, a computer output shall be taken to have been produced by a computer, whether it was produced by it directly or by the means of any appropriate equipment. So now to now to summarize the ingredients of 65B, which is related to the admissibility of electronic record, it would be the document in question as defined under Section 2 IT of Information Technology Act. Then it would be produced by a computer, that is a mobile, a PC, or a laptop, or a tablet. And then it is accompanied by a certificate as per the principles enshrined in Section Certificate of Section 65B. Now, what are the conditions of the 65 section 65B while producing a certificate? Now, the conditions are, because these are the most relevant provisions under section 65B, the computer output was produced by a person having lawful device. Second, data regularly fed into computer in the ordinary course of activities, but it should not be manipulated and it should not be tampered with. Third, that the computer was operating properly. Fourth, that the information contained in the electronic record reproduces or is derived from such information. It further shows that any person, as I stated earlier while reading the bare wording, I repeat it again, any person occupying a responsible official position in relation for the operation of relevant device. The certificate shall contain identification of records, of electronic records, let's say, and particulars from the device from which the electronic record was produced. Now, let us, for example, a corporate company cannot send its liftman or a peon to the court of law by saying that yes, he is the person who was authorized and responsible for maintaining the records. So there has to be a person occupying a responsible official position in relation to the operation of that relevant device. The statement further, the statement of the certifying officer to the best of his knowledge and belief shall be sufficient. One of the basic examples of electronic evidence related to the amendment in Bankers Book Evidence Act is that a printout of statement of account must have a certificate by the principal accountant and a branch manager and a certificate from a person in charge of computer system when tendering evidence in the court of law. Both can be the same persons, but there has to be a certificate from them. Few another examples of electronic evidence here can be like CCTV footage, a CD or a DVR, a pen drive, external hard disk, SMS on a mobile phone, a printout of that SMS, statement of the account from the bank, WhatsApp or a Facebook, snapshot or screenshot, CDRs. So all these are a part of section 65B, and few of the examples regarding which the electronic evidence can be followed. Now, chapter 12A deals with the Information Technology Act with the examiner of electronic evidence. Now, before proceeding with the 79A, I would request that there are few provisions in law which have really explained and have really dealt with in the Evidence Act. Once the statute was changed, once the statute was amended by virtue of the Enforcement of Information Technology Act 2000. Now, some of the provisions such as Section 22A, Section 45A, Section 47A, Section 53A, these are the sections which were brought in by the amendment and enforcement of, by the amendment in Evidence Act, when the enforcement of the Information Technology Act came on 17th of October 2000. For example, if we say that Section 22A, 22 section of Evidence Act deals with when oral admission to the contents of the documents are relevant. When the oral admission to the contents of the documents are relevant, but 22A steps further and it deals with when an oral admission as to the contents of electronic records are relevant. So this is what the basic difference is. Now, if we proceed further with section 45A, now 45 deals with the opinion of experts under the Evidence Act 1872. But 45A deals with the opinion of the examiner of the electronic evidence. So these are the basic differences. These are the basic challenges which came across once the Information Technology Act 2000 came into being. Further, section 47A. 47, as I said earlier, deals with opinion in handwriting. Now 45 deals with opinion of expert. 45A deals with the opinion of an examiner of electronic evidence. Similarly, 47 deals with opinion in handwriting.
थोड़ी ना हम कहें आएगा पापा लाएंगे तो इसका पानी डाल लेंगे और एक ढक्कन वो डाल लेंगे मिला के पी लेंगे एलोवेरा डाल, इसलिए फेंका नहीं, हमें पता, हम बर्बाद नहीं कर रहे हैं.
Sorry, I think there is some disturbance. Okay, let's continue. So 47A to the contrary is opinion as to the electronic signature when relevant. 47 talks of the handwriting, but to the contrary, the 47A steps further and it talks about opinion as to the electronic signature when relevant. So these are the some provisions which are relevant and which came into being once the Information Technology Act came into picture. Basic amendments, necessary amendments, for the reason that everything now is going electronic. Now the virtual session which we are performing today, I say this is also one of the ways. In earlier we used to have physical seminars, physical symposiums, or maybe we can say lectures or classes. But these days, most of us are having online classes. So this is how the advent of technology has begun, and this is how we all have changed dramatically. The society has changed dramatically, and this is how the cyber world has forced us to be or to use the electronic mechanism to the maximum. But while using the electronic mechanism, when there is a crime committed, then also there are certain investigations to be done, then there are certain incidents to be followed, then there are certain formats, procedures, guidelines to be followed in the court of law, in which electronic evidence and digital evidence is the most important format. Now next, again coming back to section 79A under chapter 12A of Information Technology Act, which deals with the examiner of electronic evidence. I say that section 79A, central government to notify the examiner of electronic evidence. Central government may, for the purposes of providing the expert opinion on electronic form evidence before any court or other authority, specify by notification in the official gazette any department, body or agency of the central government or state government as an examiner of electronic evidence. Further, it explains that for the purpose of this section, electronic form evidence means any information of probative value that is either stored or transmitted in electronic form and includes computer evidence, digital audio, digital video, cell phones, and digital fax machines as well. Now let us understand the evidentiary value of the digital evidence. The evidentiary nature of digital forensic science. It requires rigorous standards to make it irrefutable in a court of law and acceptable to the judicial officers regarding the guidelines that make any digital evidence acceptable. However, yes, there has been initial reluctance from Indian courts, let us say, regarding the probability, admissibility of the digital evidence, of the electronic evidence. But with the, we can say, with the awareness, especially with the acceptance of the higher judicial officers, now the courts are accepting the computer evidence, digital audio, digital video, the cell phones, and all the data and information stored in these digital devices. With the passing of the Information Technology Act, the digital evidence and the digital records have gained legal recognition in India, and hence their acceptability in Indian courts is legally accepted. There have been certain amendments in Indian Evidence Act, as stated earlier, Bankers Book Evidence Act, and the probably, let's say, 160-year-old Indian Penal Code has given legal recognition to the crimes committed in the electronic manner as well. Let us say, for the example of telephonic instructions. On telephonic instructions, it became quite common for banks and other institutions to take official routine instructions on phone by giving an information and by conversing with the information and recording that conversation as well. It is quite natural for a customer to provide that particular thing, but somewhere or the other it is binding. However, in the event of dispute, legal validity of such instructions, if it is being questioned in the court of law, it is interesting to note that how it will be produced in the irrefutable manner, and thereafter how it will be accepted, and how it will be standing the test of cross-examination thereafter. So in such cases, it is important for us to understand the concept of electronic evidence, digital evidence. Now further is digital, we can also say, like telephonic conversation, it can be digital footprints also. Digital footprints, which includes, it can be active, it can be passive also. But digital footprint is the trial or the trace that if a person leaves online in the internet and refers to any information communicated, or an email or an attachment stored or uploaded, broadly speaking, when the trace of that footprint is created and data is collected without the owner, then it is traveled under the digital footprint concept. Now, in most of the cybercrime these days, as a lawyer, I can say you this thing, inform you that in most of the matrimonial disputes, let us not talk of the other disputes, but the matrimonial disputes these days in the society, one way or the other, the chat done on WhatsApp, the chat done through text messages, any wrong information provided on Facebook, and any wrong information provided on somewhere on again, let's say some photographs clicked and sent on WhatsApp profile. Yes, they are one of the major example, are major type of evidences which are being used in the matrimonial cases these days. So in most of the cybercrime these days, the details gathered from the mobile towers has become a very crucial evidence. Let us say, for example, that in a case under NDPS Act, an FIR has been lodged on the accused. But when the accused appears before the court of law, he has the right to take the defense that as per the FIR, I have been alleged to be arrested on a particular spot. Whereas if my call detail records are produced in the court of law, then I may not be exactly on that location and the FIR is false. This is one of the defenses which can be taken. But For that, we have to understand that it is not only one type of act, or it is not only one type of case in which CDRs are required. In most of the cases, call detail records just to show the exact presence of the accused or just to prove the exact commission of crime. CCTV footage can be used, call detail records can be used, and thereafter the logs of the call detail records are recorded in a server in a mobile tower, which are always used as a vital evidence in the investigation. For example, SIM card in the mobile handset stores valuable information which are crucial investigate. Let us say it is a very crucial evidence for any investigator. Every registered user has an original, let us say, IMSI, International Mobile Subscriber Identifier, which is a unique identifier defining a subscriber in the wireless world, including the country and the mobile network to which he belongs. The information is stored in the SIM card, and in case of a GSM handset, the network uses the IMSI to identify the subscriber and then IMI of the handset. Now, basically, these days, if our let us say just to a basic example for a layman, that if your mobile phone is lost and you go back to the company by saying that I have lost my mobile phone, or if at all you want to lodge a complaint to the police officials, the basic thing which they want to know is that, do you know the IMI number? So IMEI number is the, let us say, International Mobile Equipment Identify number, is the unique number, 15 digits mostly, for every mobile handset, commonly find behind the battery, and it can be compared to the registration number. It is allotted by 4 maybe bodies authorized globally in this regard. But as far as my knowledge is concerned, that no two handsets can have the same number. And it is one of the very useful tools to trace a mobile when it is lost. And of course, for law enforcement agencies too. Because if they get such a valuable information within a stipulated time, they can definitely understand, they can definitely get handy information which is required for them for resolving the major issues or the major investigations. Now, last, let us also have the concept of, like we had IMEI number concept, the SIM concept, the, let us have the now the CDR as well. Now, CDR, as I defined it earlier, call detail records. Every mobile tower generates a log called call detail records, or CDR in the short form. CDR contains very valuable data such as time, duration, completion status, source number, or maybe the destination number as well, which provides the route by which the call was entered and where the call was left. So as I gave the example of NDPS Act allegations, CDRs are being used as one of the most useful law enforcement, useful evidence for law enforcement agencies for all evidentiary purposes. Now, before proceeding further, I would say that why Information Technology Act? Information Technology Act, why it is so important? Now, Information Technology Act 2000, because 65B cannot be read in isolation. It has to be read in totality with by understanding the provisions of the Information Technology Act, because Information Technology Act 2000 provides for the nature of the offenses as well. Now, beyond section 65 of Information Technology Act, offenses falling under the Information Technology Act are also given. So information technology has become an inevitable part of the lives of the individuals. And I would say not only the individuals, of every business around the globe. All sorts of crimes have existed in the time immemorial. For example, let us say theft, murder, forgery, cheating are being committed since long, and special laws have been made to punish these criminals. But with the advancement in the technology, information technology, criminal minds have now started doing or have started committing offenses, such crimes, through electronic medium, through by the use of technology. It would be appropriate to mention that data and information are essentially valuable. We should understand this fact that our data, which is available online, and the information available online is very much valuable. It is very difficult to catch a cyber criminal because he is hidden. You cannot say that directly that this person has committed this cybercrime until unless there is a threat bearing inquiry and the procedure is adopted, and then we come to the conclusion that he's the person who has committed the crime, because cyber criminal in most of the cases is unseen. In most of these cases, cyber criminals use their knowledge and their technical experience as a weapon, because they keep them updated, and sometimes cyber criminal keeps them updated more than what a normal technical person would do. So once the technology is created, most of the time cyber criminals think a step ahead for committing a particular crime. Their technical and their technical experience, I would say, is used as a weapon, because as I told, they keep them updated with the technologically as compared to the victim. Although there is no exact definition given of cybercrime in the Information Technology Act 2000 or maybe in any other act, but it provides for some of the relevant definitions which will be essential for you to understand, and which would be essential for you to go beyond the concept of what legally these terms are defined and how statutory these terms are defined. Now, let us say, for example, we all know the technical definition of a computer, but how Information Technology Act 2000 defines computer or a computer network or a computer system, or let us say data, information, a digital signature or an electronic signature, is really relevant for understanding the concept. Yes, today we are not dealing with Information Technology Act specifically, and because if we would have been dealing with the Information Technology Act, certainly I would have taken you to those definitions as well. But today we keeping the point in hand regarding the concept of digital evidence. It would be if we are committing a if he is committing a crime, if some person is committing a crime, there has to be a motive, like there has to be a money involved in the offense if there is a theft or a robbery. However, in case of the cybercrime, not only motive, but there should be the knowledge of using that computer as well. The offender needs to have the knowledge of computer and other related technological aspects while committing that offense. So that is more risky, that is more I would say heinous, that is more grave, that is more dangerous, that is more frightening once the cybercrime of any nature is committed. There have been instances in the past, especially in the area of cybercrime, where we often hear that group of men or women across different nations who have never met anyone, but they are performing illegal activities via online media. I'll quote an example for you. 2.5 years back, probably, a person was arrested by cybercrime cell in Hyderabad because he was operating a WhatsApp group with the name of Kids Triple X Online WhatsApp group. Interestingly, when he was arrested, his mobile was traced, it was investigated, and the police officials came to know that in that WhatsApp group, the modus operandi which that person was using was he had members from all around the world, let us say like the countries like South Africa, Netherlands, Dubai, Afghanistan, and all around the world, Australia, UK, US, for the reason that all the members in that particular group on WhatsApp used to send or upload the child pornographic videos, and then those videos this person used to upload on the website, sell them, and used to earn money. So let us try and understand that this is not a type of offense in which there has to be only a motive. The person sitting all around the world who was sending videos from various countries on one handset, or let us say on one mobile number, they all had the motive, and they all had the knowledge of using that device, and by committing the offense, they all were somewhere or the other related to each other. So these are the type of offenses which are being committed on the cyber crime. Now there are offenses in which some of the offenses which have taken a place during the few years is not only the defamation, but we can call it a cyber defamation offense. Earlier there were blogs, and people used to write something on the blog against any corporate house, against any company, and then when it would be viewed by other people, and if it turns out to be false, then they are also liable under the cyber defamation. Now, besides the point, and coming back to the concept of digital evidence, I would take you to certain case laws of the electronic evidence which are relevant, because this is the last part of the lecture that case laws will be taken. Now, the concept of electronic evidence can be explained better with the help of case laws which have evolved from time to time. The Honorable Supreme Court earlier decided the case of a state versus Navjot Sandhu, that is Afsal Group, 2005, volume 11, SCC 600, where a two-judges bench had an occasion to consider an issue on production of electronic record as evidence. While considering the printouts of the computerized records of the calls pertaining to cell phones, it is held that according to Section 63, secondary evidence means and includes, among other things, copies made from the original by mechanical process, which is themselves ensure the accuracy of the copy, and copies compared with such copies. It was the High Court has also observed that printouts taken from the computer servers by mechanical process and certified by a responsible official of the service providing company can be led in evidence through a witness who can identify the signatures of the certifying officer, or otherwise speak of the facts based on his personal knowledge regarding that particular matter. Irrespective of the compliance with the requirements of Section 65B, which is a provision dealing with the admissibility of the electronic records, as which I explained earlier, there is no bar to adduce secondary evidence under the other provisions of Evidence Act namely Section 63 and Section 65. It was also held that certificate containing details under subsection 4 of Section 65B is not filed in the instant case. That does not mean that secondary evidence cannot be given even if the law permits that such evidence is to be given in the circumstances mentioned in the relevant provisions. Now, this is what was held in State versus Navjot Sandhu. But thereafter came a landmark judgment of Anwar PV versus PK Bashir, again by Honorable Supreme Court of India, which overruled the law which was laid down in Navjot Sandhu Afzal Guru case. Now, this judgment came on 18th of September 2014, which referred to the statement of the objects and reasons of the IT Act. In its judgment, it held that the object and the reason of Information Technology Act is that new communication systems and digital technology have made drastic changes in the way we live. A revolution is occurring in the way people transact business. Further, they held that there is a reason that there is a revolution in the way the evidence is produced before the court of law as well. It makes the system functions faster and in a more effective manner. The Honorable Supreme Court relied upon the fact that any documentary evidence by way of an electronic record under the Evidence Act in view of Section 59 and Section 65A can be proved only in accordance to the procedure prescribed under Section 65B. They further held that Section 65B deals with the admissibility of the electronic record. The purpose of these provisions is to sanctify secondary evidence in electronic form generated by a computer. The apex court in its judgment referred that it may be noted that section starts with a non-obstante clause. Thus, notwithstanding anything contained in the Evidence Act, any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer shall be deemed to be a document only if the conditions mentioned as subsection 2 are satisfied, without further proof or production of the original. It was further mentioned that the very admissibility of such document, that is the electronic record, which is called computer output, depends upon the satisfaction of the 4 conditions. Now, the 4 conditions which are mentioned in Section 65B, Clause 2 of the Evidence Act, which I've stated earlier. So, those 4 conditions would be that the electronic record containing the information should have been produced by computer during the period over which the same was regularly used to store or process the information for the purposes of any activity regularly carried on over that period by the person having lawful control or use of that computer. The information of the kind contained in the electronic record, of the kind from which the information is derived, was regularly fed into the computer in the ordinary course of the said activity. During the material part of the said period, the computer was operating properly, and that even it was not operating properly for some time, the break or breaks had not affected either the record or the accuracy of its contents. So last clause they mentioned was the information contained in the record should be reproduction and derivation from the information fed into the computer in the ordinary course of the said activity. Further, the Honorable Court also relied upon the fact that under Section 65B(4) of the Evidence Act, if it is desired to give a statement in any proceedings pertaining to electronic record, it is permissible, subject to the satisfaction of the conditions mentioned therein. First, that there must be a certificate which identifies the electronic record containing the statement. Second, that certificate must describe the manner in which the electronic record was produced. Third, the certificate must furnish the particulars of the device involved in the production of that record. The certificate must also deal with the applicable conditions mentioned as mandate under Section 65B(2). And last, the certificate must be signed by a person occupying a responsible and official position in relation to the operation of the relevance device. It is further clarified in that judgment of Anwar PV versus PK Bashir that the person need only to state in the certificate that the same is to the best of his knowledge and belief. Most importantly, such a certificate must accompany the electronic record like computer printout, compact disc, video compact disc, a pen drive pertaining to which a statement is sought to be given in the evidence when the same is produced in evidence. All these safeguards were taken to ensure the source and authenticity, which I would say are the two basic hallmarks of the electronic record. Electronic records are being the most susceptible we can say, against tampering, alteration, transposition, excision, etc. Without such safeguards, the whole trial based on the proof of electronic records can lead to travesty of justice. Only if the electronic record is duly produced in the terms enumerated under Section 65B of the Evidence Act, the question would arise as to the genuineness, and therefore, in that situation, resorting back, it can be made to take the opinion of the examiner of electronic evidence under Section 45A. So this is as far as the evidence relating to the electronic record, which was noted herein that being a special provision, the general law on secondary evidence under Section 63, read with Section 65, shall yield on the same. Special law will always prevail over the general law. It appears that the court omitted to take the note of the Sections 59 and 65A dealing with the admissibility of the electronic records, and proved and hereby stated that the court, while dealing with the Navjot Sandhu case, does not lay down the correct legal position. Therefore, it overruled that particular judgment and held that an electronic record by way of secondary evidence shall not be admitted in evidence unless the requirements under Section 65B are satisfied. Thus, in the case where, let us say, CD, VCD, the same shall be accompanied by the certificate in terms of Section 65B at the time of taking the document, without which secondary evidence pertaining to that electronic record is inadmissible. Now, this was all about the Anwar PV Bashir, and lastly, there was because this was the landmark judgment, so I had taken some time to explain that judgment and what was basically held in that judgment, because this being the landmark judgment, and thereafter the latest judgment of Arjun Pandit Rao Khotkar, that is the civil appeal of 2407 of 2018, was also the landmark judgment, regarding which and in which again this law was retreated. So this is what the information I could gather for you people in today's symposium. I hope I have made myself clear with regard to whatever was required from my side, and I hope if somebody can just sneak in and inform that. Yeah, Mr. Mahajan, are you there?
Hello, good evening, sir.
Yeah, good evening, please.
Yeah, sir, I am Akash Garg and I'm head of media and communication for the World Cybersecurity Forum.
Yeah,
Yeah, sir, thank you, sir. It was such an insightful session for us.
yeah,
Sir, I think there is some network issues with Mr. Manik.
no problem, no problem.
Yeah, sir. So we will be proceeding with the question and answer, sir. So during while filling the form, there were some students who has asked for different questions. So first of the question is, what are the different emerging trends in the digital evidence?
Digital evidence, let us not have the, I would not say the trend would not be the right word, but yes, you can also call it as a trend for the reason that the digital evidence, we have to, as I stated earlier, that coming back to my lecture, primary evidence and secondary evidence, making it to be a part. So as a matter of trend, like earlier, let us say we used to have those floppy disks. So thereafter there was emergence of CDs, and then there was an emergence of pen drive. So slowly and steadily things have changed now as far as digital evidence is concerned. Yes, there are screenshots if we produce in the court of law of with respect to WhatsApp, with respect to the Facebook, if something has been posted, because the trend, I would say, would depend upon the basic facts of the case, depends upon the different facts to facts of the case. But yes, there are few examples you can see, please.
Uh, Good evening, sir. First of all, I would like to inform that it was a very knowledgeable and an interdisciplinary session. And I would like to state the next question, which is from Mr. Rahul Bharti.
Yeah.
And Mr. Rahul Bharti want to know about the Supreme Court's diverse opinion about admissibility of digital evidence.
Yes, I think I have made myself clear in the lecture, and now I will again state that earlier in the matter of State versus Navjot Sandhu, the Supreme Court held with regard to the admissibility of Section 65B, that is particularly with regard to the secondary evidence, but that judgment was overruled, and subsequently the judgment of Anwar P.V. Bashir versus Anwar P.V. Bashir judgment was there, in which the judgment of Navjot Sandhu was overruled, and thereafter in the judgment and the judgment of Anwar P.V. Bashir was also retreated in the law which was held in the Arjun Pandit Rao case as well. So these are some of the
Right,
landmark
sir?
judgments which can be taken to reply the answer in a better manner.
Right, sir. And sir, we have one more question from Mr. Abhishek Sharma. And Mr. Abhishek Sharma wants to know about the right to privacy under Article 21 and its effect upon the cyber crimes and digital evidence.
Look, right to privacy with regard to today's topic, because we are sticking with regard to digital evidence. As far as right to privacy is concerned, I think that is more of related to Information Technology Act, and yes, right to privacy with regard to the online privacy, I would say certainly is a topic, but I think it needs a larger discussion, and I don't think this question would be relating back to today's topic, that is with regard to the digital evidence.
Indeed, sir. Indeed. Very
Yeah.
well, sir. Sir, We would really, on behalf of Think India Chandigarh and World Cyber Security Forum, first of all, we would like to thank you for giving us your valuable time. This session was really fruitful, and it was a really interdisciplinary session. It has imparted a lot of knowledge to all the students, as well as all the professionals who are present here. So, sir, we would like to extend our happiest thank you to you for for accepting our proposal to be the eminent speaker of this webinar. Thank you, sir. Thank you so much. Also, I would like to thank Mr. Shivam Raghuvanshi, who is National Co-Convener, Think India Organization, Mr. Nirmal Sharma, who is the convener, Think India Chandigarh. I would also like to thank Ms. Pakhi Garg, ma'am, Advocate Security Forum, as well as Ms. Megha Ahuja, ma'am, Program Head, World Cyber Security Forum, India. I would also like to share with all the participants that, as you all must be aware, that we are holding another webinar tomorrow, which is on the topic of the psychology of cyber crimes. And the eminent speaker for the webinar, which is going to be held tomorrow, is Ms. Rupa Nishar, who is an assistant professor at National Forensic Sciences University, Gujarat, India. World Cyber Security Forum is also very glad to announce that we are starting with a series of international symposium on cyber crimes and issues pursuant to international laws from October 10, 2020, where we are inviting cyber professionals and dignitaries and experts from cyber domain from all over the world. So the World Cyber Security Forum is trying their best to impart knowledge as a part of the cyber awareness campaign. More details regarding the upcoming international webinars would be shared in our various social media handles as well as WhatsApp group. So I request everyone to kindly follow the various social media handles and join our WhatsApp group to stay updated. I'll be sharing the link of that WhatsApp group and social media handles in the chat box.
Thank you.
Thank you, sir.